All right, I'd say it's a 101. Let's call it to order.
Okay, thank you. Okay, Robert Pearman,
Present.
Leonard Mnuchin,
Present.
Robert Chase,
Here.
Stephen Winkle. Okay, so we have 3 members present.
Okay, let me get my I have to go to the official outline here rather than just the regular agenda so I can do the required things. Just hold on, folks. All right, quick. Oh. So did that chair's outline come from you, Katie?
Correct.
Okay.
Oh, good.
All right, I see it now. Okay. Chair's outline. Okay. All right. So this is going to item B on your agenda, where I announced that the meeting is being webcast, as you can see, pursuant to the provisions of Senate Bill 143, approved September 13, 2023. It's being held by teleconference and the physical location at 2420 Del Paso Road, Suite 105, Sacramento, California. So committee members, the usual procedure is that in terms of voting requirements, all motions and seconds will be stated on the record, and we'll have to take a vote on all motions by roll call. Item C allows us to have public comments on items not on the agenda. Understand that, we're not really supposed to take any action or discuss those items, but we can decide to refer them to the board committees, or otherwise place them on the agendas for future meetings. First, are there any public members at the CAB offices, enforcement offices?
We do not have any public members here. I do just want to note, Stephen Winkle was able to join the meeting, and you may want to do a mic check for him now. And
yeah,
oh, it looks like he did. So thank you.
Welcome, Stephen. So he can't hear us, right?
Stephen, you're muted. So if you look at the bottom of your screen on the bottom right, there's a microphone you can click on. If it turns green, you're unmuted, or to the side of your name.
It finally turned green.
Perfect. We can see and hear you. Thank you so much.
Great. All right. Well, Tricia, maybe you could request the process if anyone in the public who's listening wants to address public comment on items not on the agenda. I don't see anyone, but you may know better than I.
Yes, we have 4 attendees, 4 people signed into WebEx. So if any members of the public would like to comment on items not on the agenda, you may raise your hand by clicking on the hand icon next to your name, or if you've called in, pressing *3. We are displaying instructions and we'll give you a moment. All right, this is the moderator. I'm not seeing any raised hands, so Mr. Chair, I return the floor back to you.
Thank you. So we'll move to item D, review and possible action on the May 8, 2025 committee meeting minutes, which are in your packet. Do any board members, first of all, committee members, I should say, have any comments or changes they want to make to that? Seeing none. Tricia, could you ask the public if they have any comments on the meeting minutes?
Thank you, Mr. Chair. If any member of the public would like to comment on agenda item D, please raise your hand by clicking on the hand icon next to your name, or if you've called in, pressing *3. We are displaying instructions and we'll give you a moment. All right, I see no raised hands. Mr. Chair, I return the floor back to you.
Okay, so hearing no comments, we need a motion and a second to approve the May 8, 2025 meeting minutes. Anyone want to make the motion?
So moved.
Chair Robert Chase, I'll move approval.
Okay, Bob Chase, and I heard Steve
Stephen
second.
Winkle, second.
Okay. All right, do you want to call the roll, Leonard, or you want Laura to still do that?
Sure. Robert Pearman,
Aye.
Leonard Mnuchin, aye. Robert Chase,
Aye.
Stephen Winkle.
Aye.
All
Aye.
right. It passes unanimously. I like that. All right, so next we're going to item E, which is the enforcement program update. And will Katie or Alicia take the lead on that?
I will. This is Alicia. So we have our enforcement program update. Let's see, one of the first things I wanted to update you guys on is Jasmine is back full-time with us. She took a little time for her new little one, so she's back full-time. And then we also have a new employee, Tirza Phipps, and she is a analyst just like Mike, Katie, and Jasmine in the enforcement unit. Her responsibilities are going to be oversight for the fingerprinting process, and then she'll also be assigned cases. She's started on the cases, but she's doing a great job with us. And then I think you guys have also met Ryan, our office technician. He's been here just over a year now. So he was at our last committee meeting as well. And he keeps us in line, make sure he opens cases for us. And he has the advertising cases as well as helping coordinate with this meeting. So those are some of his responsibilities. In November 2019, we started the subject matter expert program. And with that, we had several SMEs that joined us to help us with technical expertise on our cases that were more technical in nature. And so we had a batch of about 15. I believe we're down to about 3 to 4 active SMEs that we use. So in May of 2025, we put out an application for SMEs to reapply. We opened it up to all architects that were licensed within the state of California. We received, I believe, about 125 applications. In December, we went ahead and we sent off a writing exercise for those SMEs to review a complaint that came in. It was just a fake complaint that came in, and it was, we attached some of the Practice Act violation sections that would tie to the complaint and asked them to review the complaint, to determine what the violations were and what their recommended outcome was. Those are due in about 2 weeks. So we'll take a look at those writing samples and then pare it down to a batch to do oral interviews with. And we'll go ahead and make a determination on our next batch of subject matter experts for our SME program. Up next, we have some websites.
Let me ask a question about that.
Sure,
Did you
of
say,
course.
you said that at one point it went from 15 to 4. Was that by attrition, or there wasn't enough work for people, or you fired some people from the original panel? Could you explain that?
Some people just decided that they were going to fully retire. Usually the population that we receive for SMEs are near retirement. So some of them decide to finally retire. I think there was like 1 or 2, we decided that their writing style didn't meet the standard that we wanted to hold up, and their analysis didn't. So it was kind of a combination of results, but we kept the cream of the crop, Bob Chase being one of them. So he provides us with technical expertise in our staff meetings. If we have any specific questions that are minor, then he helps with that, giving us guidance just on specifics of the practice of architecture, what is normal as far as standard of care kind of ideas. He answers and returns phone calls and emails that are received. Typically, we send him ones that are called in from architects that are from the public. So he helps with that, but we've kind of just kept the ones that provide us the best reports and analysis for our cases.
Thank you.
Of course. Any other questions on that section? No? Okay. So up next, we have some website updates. One of the previous strategic plan objectives from the prior plan was to create a video to about avoiding common mistakes. And so Jasmine Steinwert was the analyst responsible for that objective, and it turned into 2 separate videos. And those have been posted to our California Architects website. And so the 2 videos are Avoiding Common Mistakes, a guide for architects, and then another one is Avoiding Common Mistakes, a guide for consumers. So they were broken out into 2 separate audiences. And I think we were going to go ahead and play the video for that. Was that the plan?
Why not?
This is the moderator. I would need to be given the video, and that hasn't happened. So
Okay, can we upload it? I'll finish this up and maybe we can
Mhm.
send you the link.
okay,
Sure.
It's on our website, so.
okay.
All right, Jasmine, can you add it to the chat? The link to the chat? The Teams chat. Okay, send it. Okay, so up next, there's another one Jasmine was working on, which is under the forms and information bulletin section of our enforcement program update. So it was a business entity report form and informational bulletin. So that was updated on the website, both the form and the bulletin. And so she will go into more detail about that specifically later on in the agenda because it's one of our strategic plan objectives for this current plan.
Mhm.
And then lastly, the Assembly Bill 759 Architect in Training was enacted, and it will be effective starting January 2027. So I think Mike was going to speak a little on that.
Afternoon, Mike.
Thank you. I just wanted to point out, if you have a copy of the Architects Practice Act or you access through our website, that there's 3 new statutes related to the Architect in Training title. There's Business and Professions Code Section 5500.2, which establishes the program. Section 5587 allows us to investigate misuse of the program. And the program involves a licensed architect supervising each person using the Architect in Training title. So BPC 5587.5 allows us to discipline the supervisor for any misuse that they are responsible for. And then all of those became effective January 1st this year, but the program won't start until January 1st next year.
So is someone, Tim, is somebody working on drafting regulations for us to look at, or where does it stand in terms of doing what we have to do to make this work?
Yes, Tim is working on that. He's with us if, Tim, you wanted to say something. Otherwise, I'll just tell him what you told me yesterday.
Yeah, one reason I raised that, and you can address this, Tim, is the timing. You know how long it takes to get regulations through, and I'm concerned, it seems like it's long away, but if it starts working in January 2027, you know, we gotta make sure we got regs in, ready and through in time, unless I'm missing something.
And make Tim Murata a panelist.
Robert, while Tim's getting promoted, this is Laura, that Tim does have regulations that'll be on the board's February agenda.
Okay.
I can let him speak to it if he gets promoted. So we do think we can make the time frame.
Hello. Yes, as Laura said, I have language that is being reviewed by our legal and regulatory counsel right now to bring to the board. We've already done a fiscal analysis of the impact because we are going to need to charge a fee as part of enacting the title. So we're underway, and I expect to be able to get it done within the year.
I heard Tim guarantee it'll be done in a year. Thank you.
All right.
I hope.
Okay, we'll look forward to that on February. Yeah.
And just for some guidance in this area, I spoke to Tim about this, about the numbers of applicants expected so that we can think about the impact it's going to have on the enforcement unit. And Tim, I think you've told me that at least for budgetary purposes, you're shooting for 1,000 per year applicants.
Yes, we're expecting a delayed implementation for this, so we don't expect a rush of candidates to apply for this title, but more of a trickle of candidates of our existing population to apply for it over time.
Okay. Before we go to the other items in the charts on the enforcement program, any board members, committee members have any questions for the staff so far about the things discussed under enforcement?
No, I think you raised the questions that I had.
Okay. Continue, folks.
Trish, if it's okay, can we go ahead and start the video?
Yes. Hold on. I'll have to click on some buttons behind the scenes and then it should play.
Thank you.
Uh-huh. Hold on one moment. We'll try that one more time.
We should also get it done.
I can go over the data. What'd you say?
Summaries.
Sorry, it's taking a little longer than it usually does. We'll try this one more time.
I think while Trisha is getting the video going, I'll kind of go over the enforcement program data. Oh, never mind.
Avoiding Common Mistakes, a guide for architects. This video from the California Architects Board will describe common mistakes and violations often encountered in the field of architectural design. Whether you're a consumer embarking on a new project or an architect refining your professional practices, these tips will serve as a guide for a smoother and more productive journey. Did you know? Did you know the practice of architecture is governed by the Architects Practice Act? All licensed architects should have knowledge of the rules and regulations contained in the Act. Violating the Act can lead to an architect being reprimanded, fined, suspended, placed on probation, or have their license revoked. To review the Act, visit the board's website at the following link. let's talk about avoiding common mistakes. Our first tip emphasizes the importance of written contracts. Just like a house needs a solid foundation, the foundation of any architectural project is the written contract, which lays out the project's scope, budget, schedule, and contractual obligations of each party. Written contract requirements. The Act states an architect and their client must execute a written contract prior to beginning services. The written contract requirements are: 1. A description of the project for which the client is seeking services. 2. A description of the services to be provided by the architect to the client. 3. A description of any basis of compensation applicable to the contract and the method of payment agreed upon by both parties. 4. The name, address, and license number of the architect, the name and address of the client, and the project address. 5. A description of the procedure that the architect and the client will use to accommodate additional services and contract changes, including, but not limited to, changes in the description of the project, in the description of the services, or in the description of the compensation and method of payment. 6. A description of the procedure to be used by either party to terminate the contract. 7. A statement identifying the ownership and use of instruments of service prepared by the architect. 8. A statement in at least 12-point type that reads, "Architects are licensed and regulated by the California Architects Board, located at 2420 Del Paso Road, Suite 105, Sacramento, California, 95834. A written contract should be detailed and comprehensive. It should outline the entire project and include the architect's and client's expectations, as well as contain the required elements. This helps avoid costly misunderstandings. Ultimately, the contract should protect both parties. Of course, no journey is without challenges. The key is to have a written contract that establishes how to deal with a challenge if one arises. Let's examine the consequences if no written contract is established. Case study number 1. Written contract. Our first case study involves an architect hired by relatives. The architect claimed a written contract was not necessary because they were family. As the project progressed, disputes arose regarding project scope, timelines, and fees. The absence of a clear contract left both parties in a vulnerable position. The clients were left with a fully graded pad of land that they could not afford to build on. The architect was issued a citation which included a $5,000 fine for his failure to execute a written contract. Case study number 2. Written contract, willful misconduct. Let's look at our second case study. A client hired an architect for their home that was damaged in an earthquake. The architect did not execute a written contract with the consumer, failed to detect and report the condition of a damaged masonry fireplace, and filed a mechanic's lien against the consumer. The architect's actions constituted willful misconduct, aggravated by failure to execute a written contract. The board disciplined the architect and revoked his license. In both cases, the lack of an executed written contract meant that when issues arose on the project, neither party were protected by a properly executed written contract laying out the terms they had agreed to. The lesson here is to always have a written contract executed. It not only protects architects, but also provides clients with a clear understanding of the agreement terms and how to resolve conflicts. Case study number 3. Willful misconduct, recklessness. Let's look at another case study that contains many violations. An architect delayed a project for months and failed to complete contracted plans. In preparation for construction, the architect recommended demolishing the client's existing home. Following demolition, the clients were unable to get a construction permit due to the architect not completing the construction documents. The client had to rent a different home for 3 years until construction was complete. They also had to hire another designer to complete the project. The first architect refused to release his drawings unless paid an additional $35,000. He later increased the amount to $65,000. The architect's actions constituted the following: incompetence, willful misconduct, and recklessness. This caused the clients great financial harm. The board later disciplined the architect and revoked his license. Case study number 4, incompetence. Now let's explore a case of incompetence. An architect, driven by an alleged desire to cut costs, intentionally specified bolt dimensions that were below building code minimum requirements, possibly compromising structural integrity. This not only could have jeopardized the safety of the occupants, but also resulted in consequences for the architect, who was issued a citation which included a $2,250 fine for his actions. Case study number 5, negligence. In extreme cases, an architect's actions or failure to act can result in issues that put public safety at risk. Let's look at an action involving negligence. An architect was hired to serve as the architect in charge of the building of a new elementary school. Due to the architect's failure to perform the duties required of an architect in responsible control of such a project, the performance of the inspector, consultants, and contractors were allowed to fall below acceptable standards. The board found 180 individual instances of errors, omissions, and violations of law in the school's construction. As a result of the numerous building code violations, the school was condemned, demolished, and rebuilt at a cost of $4 million. The architect's actions constituted extreme negligence and caused the clients great financial harm. This led to the architect being disciplined by the board and resulted in the revocation of his architect's license. Continuing education. Another common violation entails the continuing education requirements for architects when they renew their licenses. Architects are required to complete 5 hours of continuing education coursework on disability access requirements, and since 2023, 5 hours of coursework on net zero carbon design. Some architects either fail to complete the coursework in the 2 years prior to renewal, fail to keep records of coursework completion, or wait until after they submit their renewal application to complete the coursework, which are all violations of the Act. The board audits 3% of license renewals each year, and the architects that fail their audit can be issued an administrative citation and fine. Conclusion. As we have seen, having a written contract and following it is the key to a successful project, and failure to follow the Act can result in severe professional, legal, and financial consequences. Thank you for joining us today as we discussed common violation case studies, highlighting the importance of following the Act. We hope these tips help you better protect yourself the next time you engage in an architectural design project. Questions or complaints. The board has the power, duty, and authority to investigate alleged violations of the provisions of the Act. The board also has specific authority to receive and investigate complaints against its licensees and to discipline violators. Do not hesitate to call or write the board with any questions or concerns.
I feel like we should clap.
Very
So
good.
that is a video that Jasmine worked really hard on getting finalized and getting up on our website. So does anybody have any thoughts or anything they want to add?
I think it was very well done.
Yeah, very
Yeah.
professional.
Who was your narrator?
Someone from the Office of Publishing. They helped put the video together.
Okay, so up next, we have the enforcement program data that I wanted to go over. So I compared the last 2 full fiscal years in this data. So if you compare it, most of the data is pretty similar to what it was in the 23-24 fiscal year. But in 24-25, our complaints that we received went down by about 50. The cases that we closed were about the same. The average days to close went down a little bit. And then the number of pending cases is about the same. The data for the complaints that are received include 20 of the conviction cases that we had opened, and then we also had closed them. Nothing had come from those convictions. There was no disciplinary action from those. We went ahead and we issued 130 citations, and 131 of those were final this year. So that was up about 40 citations, and that very well could be due to the CE audits. With the disciplinary cases, we have 3 in this last fiscal year that have been pending, and 1 was finalized. And I believe that one was part of, no, it wasn't the one that we heard at the hearing, correct? No, it was a license that was, we were going to suspend his license, but didn't he close his license? Like, a loss for words. You know who I'm talking about?
Sorry.
Oh, okay. Well, I'm lying to you. I don't know. I don't recall which one that was. But if you need that information, I can go ahead and get it for you. So up next, we have some summaries that are from the last meeting. So any summaries that you guys haven't seen in this meeting, they're all the summaries that have for citation cases that have been closed since the last meeting. And so I think Mike was gonna go over a few of them.
Yes, thank you. So these are the published summaries. If on page 24 through 37 of the PDF packet, you'll see that most of them involve violations of Business and Professions Code section 5536, which is advertising a person as an architect who's unlicensed, or a company as an architectural firm without a licensed architect in responsible control, and California Code of Regulations section 134, which is advertising using the word architecture to describe a business's services. A lot of those included violations of Business and Professions Code section 5536.1, which is where an unlicensed person has designed a project that is not exempt from licensing requirements. For example, an unlicensed person designed a 62-unit senior apartment center. Another one designed a commercial boba restaurant, new construction. There was a truck wash. There was a steel garage, and there was a 7-unit apartment complex. So all of those require a license to design those. They're not exempt. Exempt projects would include things like a single-family residence, less than 3 stories and a basement, or commercial tenant improvements. So you can do those without a license, but these other projects, including a lot of non-wood frame structures, require a license. So anything involving steel or concrete structures requires a license. There was 2 cases involving licensees in this batch. They both included lack of a written contract or missing elements from their written contract. One involved that plus negligence, failure to exercise responsible control. And this was an architect who was essentially aiding and abetting one of the other unlicensed people in this pack. And Katie, did you want to mention something about this? It's an interesting case because this licensee ended up being cited instead of disciplined.
So yeah, we had an unlicensed person working with a licensee. The licensee was not on the contract as Mike described. And the unlicensed person, under their business website, like was advertising architectural services, and they included the licensed person on the website as a, I forget the term, but it was like some kind a certain kind of architect. It had like an architectural, maybe just architectural designer. And it turned out that the licensee was actually overseeing some of the work, but wasn't on the contract, and there wasn't a BRF business entity report form on file to provide being responsible control. And partly back to what Mike said, we decided to do a citation instead of an accusation because the licensee was very cooperative with us and understood what he did wrong and was making amends and made the revisions we asked for and seemed to be, you know, apologetic to what occurred. So there were many things we considered, but that was kind of the gist of it.
Another case that stood out, and we've seen this too much recently, is people creating fake architect stamps. And you'll see that
Whoa.
the Jones case here. But I wanted to mention that we've also had quite a few recently that appear to be just pure scams. And the worst offender that we have right now is through a platform called Fiverr that is used for hiring people, handyman, babysitters, things like that. And people are going on there and advertising architectural services. And we've had probably 5 of these in the last year where they are actually showing on this platform that they have either an architect's license, they have a paper license, which they have forged, or they have a stamp that they have forged, or they refer to their own projects, which are actually some other licensees' projects. So it's a serious problem, but it's not easy for us to deal with because the people who use this platform are generally anonymous. There is no physical address for them. So what we've focused on is getting the platform to delete their profiles, but we generally can't find them, even if they're within California or the United States. We have no idea. It's hard to tell from that. The problem with that particular platform is that they also take payments directly through the platform. And so there's, once you pay these guys, it's gone. And so generally we hear from the architects who have heard from the clients saying, where are my plans? And the architects are like, I have no idea who you are. And we trace it back to this Fiverr platform. So it's an issue that we discussed a little bit at the last REC meeting. And we're following up on it as quickly as possible, but it's a very difficult situation, and I think that's true in general for the world these days. I also wanted to point out that many of the summaries, as the summaries indicate, many of the people over the last year were repeat offenders, where they had either received a citation previously or a letter of advisement previously. And I think there's about 6 of those. So that's an issue that we're trying to address also. That's it for me.
All right. First, committee members, any questions for the staff so far on this?
Is there, I guess there's no way to subpoena the payment records or anything like that of the website, of the Fiverr site?
That is my understanding.
Because follow the money is always the first rule in something like that. But that's amazing.
No, it's a huge loophole.
In that regard,
Oh.
back in I just follow up on that point, in the May meeting in the minutes, it noted, we had talked about Yelp and it said the investigation into Yelp's practices is ongoing. Is there anything new about Yelp in this particular period that you've learned or can do about?
So the problem with Yelp is generally the categories that designers are advertised under. So the closest category for most building designers is architect, and Yelp has been unwilling to change that fact. So what we've been having the unlicensed people do who have been labeled as architects, some of them do it themselves if they have a claim profile and they can change that. But if they don't have a claim profile, we're having them contact Yelp and file a complaint with Yelp and asking them to change the profile to something else. There's a number of other categories that we think are appropriate, but right now, one of the biggest problems is it doesn't really appear to be a lot of human direction for the Yelp advertising. It's all automated, so they're not willing to really change that, except on a case-by-case basis.
I mean, this is Steve. One of the essentially, this is really fraud at a certain level if you're representing yourself and taking the money and doing nothing. Is there any way to do an alliance with other registered professions? I mean, what's to prevent our situation would be no different than somebody calling themselves a doctor or a podiatrist or a lawyer or a registered nurse, whatever. Seems like an alliance of registered professionals going to the legislature and saying that I expect this is probably a common problem for every profession. And it seems like that would be the best way to get the legislature's attention, is basically saying that these platforms are facilitating fraud.
That's true, and it's
Not-
something maybe we could work with the Attorney General's office on.
Yeah, I mean, it's not just us. I expect this happens to every profession, of people representing themselves to be something they're not, getting people to sign up, give them the money, and taking off into the ether.
Any other comments or questions on the committee members, first of all?
Yeah, this is Bob. A question for Mike. What other categories potential that somebody could, go to besides architect?
Ryan, what do you think?
Usually, Ryan Riddell, I'm talking, sorry. So generally, a lot of the time when we are instructing them to change their categories, they will change it to perhaps like general contractors. Unfortunately, for a place like Yelp, their aggregate is very vague. So there should be a category for drafters. I know several different subjects and cases where I had them change their profile. They unfortunately, they have tried and failed with Yelp to say hey, could we get a new category for us? Because there should be an ADU design category. A lot of this stuff could have been avoided if they just didn't make their categories so broad.
Or just designer?
Yeah, designer. I
Yeah.
mean, I'm sure they can make a case that the term designer could be too vague, but I think it's better than nothing. Absolutely.
Like home services or something?
Home services, remodeling, there's a lot of things they can do that they just choose not to.
I think the main category used is architects and building designers. And that's a category. And we've come to them before and asked, can you split that up? Architects, a separate category. Building designers, they basically said.
It's interesting. The building designer category goes back, I think, to the 80s or 90s. I don't know. Steve may know when that was disbanded a long time ago.
But there was actually competing sub-licensure or separate licensure for people who could do a certain category of projects that would. It was there's also the ongoing discussion between architects and interior designers, about carving out licensed professionals from what was ordinarily architectural practice. But this is like a whole new, level of where, I mean, in terms of like the design registered building designer or something like that, is people were at least delivering on what they were telling the clients they were doing as far as project work went. Here, it sounds like they're just taking the money with no return at all.
A question,
right.
this Bob again, a question for Mike. What kind of correspondence have we had with Yelp to try to get them to?
Well, we've gone through their customer service. They were not responsive to us because they are pretty well protected by federal internet laws. So we have had more success, I think, having their actual customers, the actual designers, contacting them directly and complaining about this. And so they have gotten better responses than we have. Because all we can do is threaten them with a lawsuit and they say that we're immune, so tough.
New world.
Whereas their customers can threaten to not use them, so.
I had a question, Katie, on some of the citation descriptions. Sometimes it's mentioned that a fine or citation was paid. Should I presume in all of the cases, if it doesn't say that, that means they had not yet paid the fine or citation, or is it more haphazard than that? And I shouldn't read that too literally.
So the ones that actually say they were paid, we're just letting you know they actually did. We did receive a check for those. The ones that don't indicate it or considered unpaid haven't paid for this time.
Or they might be making payments.
True. Yeah, that could be. So no, we wouldn't notify it as satisfying payment or whatever until the total amount was paid in full.
And in that regard, still feel like our collection agency referral out is doing a decent job. Any thoughts on that?
We had a door shutting when you were saying part of that. I know you asked about the collection efforts, but I didn't catch your whole question. Can you repeat that?
Yeah, is the use of that external collection agency that we've implemented the last year or so, do you still feel that's bearing some fruit in terms of getting paid? Or
So we actually use an internal collection agency now. We did have an external one several years back, but we've switched over to an internal one. Unfortunately, due to some staffing shortages, that's kind of been put on the back burner some, but we should be able to start picking that up again this year. But we have sent over, I think, approximately 20 cases over to collections. And I'm not sure if we have received anything from that.
It's a new to us, and there's been a little bit of delay getting the cases over, but I think we've recovered on one so far. But that's probably been in the last 3 months. We've probably sent 20 cases over, and we've collected, I think, one.
is it internal to the Architects Board or internal to DCA, or what are you referring to when you say it's internal?
It's internal to DCA. So prior to this, we had an external contract with Cedar Financial. And so since then, DCA has created their own, more of an umbrella collection agency for all of the different boards to use for collection efforts. So we don't pay an external contract for it. It's all taken care of, I think, out of our pro rata funds.
I thought before, well, we can discuss it. I thought before we didn't really pay, well, they paid out of collections, the one we use external.
That is correct.
So
it was a percentage off the top of what they actually collected.
So if we're being charged for the DCA's internal and they don't collect anything, we're paying money out that we didn't pay out when we used our own external agency, unless I misunderstand the arrangement.
I'm not sure exactly how it's funded. And so Do you know by?
This is Laura. I don't know. That's a good question, Robert. We can check on the funding. I think it's just a service DCA provides as part of kind of the overall services they give to boards and bureaus within DCA. So funded through our larger pro rata, but I can check to see if it was an add-on cost or not. I think the idea was that because lots of programs had a similar need, that it would be easier if DCA had a master contract that we could use versus everyone administering their own. But we'll check into a little bit more into it and send you the follow-up information.
Yeah, I can see the logic. I guess I had missed that we had gotten rid of the external. I didn't know that happened, but maybe I just missed that. Okay. Moderator, can you ask any members of the public if they have any comments? There's no action under E enforcement program update, but of course, public comment is welcome.
Thank you, Mr. Chair. If any member of the public would like to comment on this agenda item, please raise your hand by clicking on the hand icon next to your name, or if you've called in, pressing *3. We will give you a moment. All right, this is the moderator. I see no requests for comment at this time. Mr. Chair, I return the floor back to you.
All
Chair,
right,
this is Chair Bob Chase with a question for staff, if I may.
you may.
We've been discussing Yelp as a platform, but as I recall in years past, there was House, there were several other on. Have we had any success in getting them to change their categories?
I think that they're not as big of a problem because people can change their categories themselves, whereas Yelp appears to have this automated designation. That a lot of people, when we contact them, they're like, I didn't choose that. I didn't call myself an architect. What are the categories under House and Build Zoom? Similar?
They do have similar categories, but I've found that places like House are more specialized, so people tend to be in the correct categories more often, simply because they have a more broad amount of them. Far fewer actual violations at those websites compared to Yelp.
So do they have a House, for instance, a category for designer as opposed to architect?
Yeah, I believe they also have regular designer as well. I'm trying to think of the best way to put this. I've also found that I would say at least a dozen in the time that I've been doing the advertising cases, the actual subject would say, oh, I hired a social media person to do this for me. And that kind of stuff happens too, as well, which, I mean, it's still their responsibility, obviously. We still make them change it. But there's a lot of different reasons as to why these categories can be wrong. We have had people who've been complained about and they didn't have any violations. Then 6 months later, they did, like on Yelp, because someone decided to change a category over there. You know, social media is a really, really weird landscape to police simply because they find new ways to present social media. And it's tough with Fiverr because Fiverr is not an American company. It becomes a much bigger deal. Like it's harder to deal with. Honestly, I don't think people should be doing business on that website either way. A lot of fraud happens. So, but that's me. Sorry.
Thanks, Ryan.
Yeah,
Thank you, Chair.
I just looked on the computer and there's actually a button for architecture and design on the Fiverr website.
All right. We're in with the item F1. I defer to staff who will start the presentation of F or F1 in particular, if that's how you want to do it.
Okay, we're on page 38 now, talking about our strategic plan objectives. There were 5 strategic plan objectives identified before the last meeting. We went over these at the last meeting, so we're going to give you a brief update on each of them. First one, F1, on page 40, asked us to evaluate the board's fine structure and to see if we could increase fines in our citations with the idea that that would deter violations. So we looked at the limits on our fines and found in Business and Professions Code, section 125.9, which is attached to that item. Business Professions Code, section 148, and California Code of Regulations, section 152, that our fines are aligned with those of other DCA boards, and that BPC 125.9, which is encompasses all of the DCA boards, not just Architects Board, but it sets a limit of $5,000 per investigation. So we're already at that limit. We can fine under our CCR 152 up to that amount, and then we can increase it by increasing the number of violations in a citation. So we have had $10,000, $15,000, and $20,000 citations. So we don't really consider that a huge problem with deterring Practice Act violations. But to the extent that an increase would be warranted, we would have to rely on DCA increasing their cap. So instead, we have focused on encouraging payments by allowing people to pay less if they make a timely payment. We've also tried to discourage violations by adding cost recovery. So if we have to have a SME or a Deputy Attorney General involved in a citation, then we have to pay for that. And it is our board counsel's opinion that with the correct notice, we can pass that on to the licensee or unlicensed person that we are citing. So we haven't had anyone challenge that yet, but we're trying that currently. So those are the efforts that we're making right now as far as fine amounts are involved. So that's all I have about F1. I can move on to F2 if you like.
Just so there's really no action to be taken at this point, since we're satisfied with the current scheme, or any change require the DCA statutory changes. So we kind of will leave the regs, if you would, in code alone at this time.
Correct. The only action would be for you for feedback on whether you agree that objective has been completed.
Okay, well, I don't consider that action, that's just feedback. I'm satisfied with your report on that subject.
Yeah.
Any comments from the committee members?
I guess just to make sure I understand is that our fines are in line with those of other similar agencies.
Correct.
Okay, I think that's all we can do at this point.
Thank you.
All right, F2. And what we'll do,
Item F2.
moderator, is we'll do public comment at the end of F as a whole.
Okay. So the objective in item F2 is to determine whether statutory or regulatory changes could be used to let planning departments know that they should be verifying licensure before approving projects that are not exempt submitted by unlicensed designers. All right, so that's a mouthful, but it's a very important concept. So right now we have statute that clearly says that building departments have to verify licensure before issuing a construction permit. So they have to verify if it's a non-exempt project, like I described before, anything other than single-family residence or commercial tenant improvements generally. If it's a non-exempt project, the building department has to verify licensure. Now, practice of architecture, the definition of the practice of architecture in BPC 5500.1 clearly includes planning documents. And the next statute, 5536.1, requires a license for anybody that's designing a project that is not exempt. So then we turn to 5536.2, which is the statute that says that building departments have to verify that licensure before issuing a permit. And if you read the very top of it, it talks about a permit as condition precedent to the construction, alteration, improvement, etc. Problem is that it's a little vague, and it's created a loophole that allows planning departments to approve unlicensed designs of projects that should require a license. So that it's illegal to design the projects, but currently planning departments don't verify the licensure. So if you look at the next page, I mean, just for illustration, I've added the word planning to that first sentence. So that's what it would look like. That's the kind of action that we would eventually take, either through modifying this 5536.2 or through some other maybe regulatory clarification that might be easier. But just for illustration, this is what's missing from this statute that allows people without a license to design projects that do require a license, as long as they get a licensed architect to sign on and stamp the plans before it goes to the building department. So this includes planning departments all over the state, California Coastal Commission, and any other department that isn't specifically issuing a construction permit. So we're trying to address this problem, or we've identified this problem. So our question to architects and lawyers that we have access to is, do you agree that planning departments should be verifying licensure? Or is this just part of normal practice that we allow unlicensed people to design these things as long as an architect signs on to them before it's constructed? So that's the overview. The big question is, how much effort do we want to put into changing this situation? Because we see a number of these cases, and there's certainly a potential for consumer harm, because coupled with an architect who might not review plans in great detail before stamping them, it becomes an issue of unlicensed people designing whatever they want. Generally, we're talking about, 3-story, 4-story houses and apartment buildings is where we've seen it. And sending those to the planning department. The other issue is that they're also advertising that they do this. But what we don't know as your enforcement analysts is how important this is to the profession and how much effort we should put into fixing it. Because right now we believe that the law says what we think it says. It's just that people are reading this 5536.2 to their convenience. And the planning departments don't want to go to the effort of verifying the licensure. So there's this loophole for unlicensed designers to do these big projects.
So even if, the architect community says it's not a big deal, your position is still, if if the unlicensed person is submitting this to planning department, he or she is technically committing a misdemeanor. Isn't that how we read the statute?
Correct.
Yeah. So it's kind of hard for me to swallow us letting that just sit out there in the ether, knowing what the practice might be. And then the other thing is we add the word planning. So far, the planning departments have not been attentive to our desires. What's the evidence that if you just put that word, all of a sudden they'll start following the laws we say? I don't know that either. I guess part of your question about what's the industry sees, it may affect whether they really enforce that additional word or do business as usual. I have no sense of how that might work.
Well, it's a good point because we don't really have jurisdiction over planning departments and building departments, but the building departments do follow this law. And it's clear. And so it might require some outreach to the planning departments. But we need to know how much effort to put into this.
I think this
Chair,
is, go ahead, I'll wait.
This is Bob, Chair. Having been here for many years now and seen this come up quite a bit, a few thoughts. I think it is important that we get the planning departments to review this for licensure. That said, it's not required in statute or regulation at this point in time. Suggestion, I think building departments are pretty much up to speed. We've also been dealing with the group CALBO, which is the statewide organization of building officials. For years, we attended every one of their meetings around the state, and very good relationship. And they were excellent in, I think, promoting, our regulations to their members, to their building officials. Same isn't true of planning departments. However, I think a couple of approaches we could take. Similar to CALBO, there's a group called the APA, American Planning Association, and each state has its own designation. We could reach out to the California APA to see how we could get this out to their members. They may do it voluntarily. That would be ideal to ask them to have all of their planning departments, require their planners to check for, licensure if necessary. The other alternative is to reach out to city managers and or city county attorneys as well to let them know. And as our attorneys on the board may know, that could be the most valuable one because they may be the ones that realize, we need to protect our jurisdiction. Let's do this correctly, and get them to do that. Jumping back to, I think, what we found years ago, one of the real reasons for this and the issues that it comes up with is that when a client hires an unlicensed designer to do a project, they may design it. It could be a really good project. It gets planning approval. They go through planning commission and get approval. Next step then is to submit to the building department. Well, when the client assumes that their plans that their designer has submitted and got approved by planning commission will just, should now easily go through building department process. They're stopped. There are a lot of often code violations in the documents that the designer was not aware of, that an architect would have been. And so the owner or client is caught off guard. Well, why is this happening now? And I think that's one of the reasons we want to get it caught early on with planning departments requiring it so that there's a smoother transition between planning approvals and building department approvals. Right now, there's that separation and we can't control it. I don't know how often it happens, but it can be timely and costly for a client who is assumed they've got a good project designed and it just hits a wall when it goes to the building department. A suggestion is to reach out to those groups. I totally agree with Mike in adding the word planning in there. I think that's very helpful. But I think we perhaps could try to reach out to some of the other organizations that relate more to planning than building department of the state.
This is Steve. I think this is a big deal. Bob hit on several of the points. I'm looking at 50.1 sub paragraph B. architects' professional services may include any or all of the following. Item 2, planning, schematic, and preliminary studies. I think the language is already there. I would actually take out the may and just say, change the title, the text to architect's professional service includes any or all of the following. That's the first small change I would make. But the other thing is, thing is, if, let's say, an owner hires an unregistered person to do a planning study for a type of building that would otherwise require a registered design professional, and they get a planning. The other thing is, I tell I'm a building code consultant. I'm not planning. I don't do planning, because planning is a different planet than building. And they don't speak well to each other in most cities. So it's not surprising that there's a resistance or a misunderstanding on the planning department's end from what happens in architecture. But basically, let's say you get a building approved for a non-registered design professional for a 4 or 5 story multi-unit apartment building where it has a single set of exit stairs, or it's over height for what they characterize as the construction type. Then when the owner gets to the building department, he finds that the planning approval is worthless because he can't afford to build, or he can't rent the way he thought he could, the project that the planning department has approved. I would submit that in addition to the people Bob talked about, that we should approach the California Building Industry Association and BOMA about the people who are the client base, who, if they end up hiring an unregistered design professional at the wrong part of the process, is very well going to end up with an unbuildable project when they actually get to the point where they try and involve a registered design professional, an architect. So that I think this is a real problem. I mean, most of the jobs that I work on are large enough that the planning documents are almost invariably done by architects, so that we don't have this, because they're bigger than the projects we're talking about. But the ones that are like maybe slightly over height, a 4-story single-family residence that's under the building code, not the residential code, or a multi-unit apartment building, that the planning, if the non-registered professional is not up to speed on what's going to be the building code issues, they're going to make horrendous mistakes that's going to mislead the owner. I think that we need to engage people who develop these projects about the misstep of not hiring an architect at the beginning of the process.
I think you're right, Steve. Unfortunately, I think a lot of the people that probably get into the situation, the more sophisticated developers, I think, are pretty aware that they need an architect and they're going to have and they cover the bases. So it's probably more the people who are, as Mike mentioned, the 3-story rather than 2-story, just outside the limits, that they're the ones that probably aren't sophisticated enough to know there's an issue here. And they're the ones that get caught in the situation.
But we need to remind that I think the APA is a really, we should be approaching those people, and also the county council, or even the building. Most jurisdictions, they have different arrangements, but most jurisdictions, building and planning are under the same community development department with a head. So, I mean, basically approaching the county council or the city council, or the city attorney about, that your community development department should make sure that your building and planning departments are talking to each other and using the same set of rules.
Right. And typically those jurisdictions have a community development director who oversees both planning and building. So, that would be a resource to reach out to.
Yeah. Is there an organization of community development directors?
Not that I'm aware of, other than APA.
Yeah, it's separate from the APA or something like that.
Any comments?
But I think, so I just think we need to address that since we are a consumer protection agency.
Yes, agreed.
So this is Laura. We may want to start with just a mailing to the planning departments, because we haven't really been communicating with them like we've done with the building officials. So we can at least try that. we hear back from and do some follow-up information and then see if they're willing to meet to discuss it. Definitely, if we needed a regulatory or statutory change, we would need to go through that process anyway to demonstrate that we tried to work together. So that could be a good step for us to start with. Good suggestion.
I think just as a mailing with a very simple description of the parameters of what unregistered design professionals can do versus what architects can do, just so they understand the threshold.
So when we have found out about these cases, we have taken action against the unlicensed designer. And in many cases, we have sent a letter from our architect consultant to the planning department. I can't remember ever getting any feedback from them on that.
I've never seen it.
But we will wrap that up.
All right, why don't I exercise prerogative, and what I'll do, moderator, since this was an interesting discussion with some options on the table, why don't we move to public comment on items F1 and F2 now before we conclude any decision on F2?
All right. If any member of the public would like to comment, please raise your hand by clicking on the hand icon next to your name, or if you've called in, pressing *3. We'll give you a moment. All right, this is the moderator. I see no request for comment. Mr. Chair, I return the floor back to you.
Thank you, thank you. So Laura, while the agenda says action requested, I get the sense from the committee that rather than going straight to a statutory regulatory change now, we'll first state our position that planning is already expressly implied in the relevant regs and law, and communicate that to at least the planning agencies, if not APA and others, and see if that has any effect. If that's our position, is that sufficient for your guidance, or do you feel you need an action item motion from this committee?
I think that's good. That guidance is helpful. Yeah. And we can report that out at the board meeting. Thank you.
All right. All right. Thank you all for that. And we'll move to F3.
Do we need to do?
And
Okay, on item F3 is on page 55. And we were asked to research our regulations and statutes to ensure that we are keeping up with current technologies and practices. And we have kind of focused on artificial intelligence in architecture and the use of electronic stamps and signatures in architecture. With regard to artificial intelligence, we previously discussed the basics of artificial intelligence at our last meeting and the applications to architecture. This year, I've attached a couple of articles. One contains a link to a survey done recently that shows that about 59% of architects do use AI in their practice, either in the design process or in project management, or both. I've included an article about the different tools, AI-based tools being used in architecture. And I've included a bulletin sent out by the board last July, just kind of broaching the topic of the use of artificial intelligence in architecture without really establishing any policies, but pointing out some of the potential issues. The REBA survey, and I don't know if anybody had a chance to look at the survey document itself. It's a very nicely prepared overview of AI in architecture. Talks about many of the concerns that are raised, including security, accuracy, and reliance, confidentiality, and copyright issues. And that's without even broaching the ideas of problems of energy consumption, lack of training, and job displacement, which are also all addressed in that document. And I just wanted to point out that there's I just got this today, an invitation to an AIA California seminar being held next week called Your Next Hire Might Not Be Human, How AI and Outsourcing Are Rewriting the Rules. And talks about the issues that I just mentioned. So in California government has delegated authority over AI regulation to a couple of agencies called the California Government Operations Agency and the California Department of Technology. They both have a lot of great information on their websites and review of all of the legislation that has been passed or failed over the last year regarding the use of AI. Seems like the state is moving towards focusing broadly on transparency instead of regulation of AI. So if we were to get involved at all, I think that the entry level action that CAB might take would be to require disclosure of the use of AI by architects, or at least put together a policy statement encouraging architects to do that. And what that would look like is if you look at page 5574, look at page 74, which is the written contract requirements. You could include a written contract requirement pretty easily to disclose the use of AI in the design. Or we also have a regulation, CCR 160, where that would fit. So just for illustration purposes, not that we're proposing this, but just to see what that would look like, that we already have a full disclosure element of professional rules of professional conduct in CCR 160E. So it would be something like that. But if we were to take any action at all, I think that that's where we would start. And I think that that's what consumers would be most responsive to.
One of the items mentioned was you considered evaluating Governor Newsom's AI-based permanent initiative. Did you really do that? And in that connection, I seem to recall, I thought there were a couple of statutes, maybe one dealing with the fires and one dealing with maybe a separate industry like restaurants or something that kind of invoked AI to short circuit the process. If so, has though the practice of those statutes or effect been evaluated?
We did discuss that at the last meeting last May. I don't know what the result has been after a year. We'll look into that, find out what the comments are on that use. I haven't heard any horror stories or love stories. So.
Chair, this is Bob, if I could jump in there, and Steve may have some input here too. The use of AI, I think, in the architectural profession, where it's much more subjective, is, I think a big concern, as opposed to the building departments. I know LA DBS is using it per Governor Newsom's directive. I think the code compliance is much more objective than the actual design of the building. And I think it probably lends itself more to, using AI. Bigger challenge in the design of the buildings itself. I don't know, Steve, have you any thoughts on building code inspection?
Yeah, they're diametrically different than what you said. But my experience, well, no, I mean, basically, I'm really concerned because if I do a Google search for a code question, the first thing that comes up is an AI generated response. which is about 95% accurate. But everything that I'm trying to find out is in the 5% that's wrong. And having participated in the code development process long enough to know how illogical the code development process is, the code is not a single document generated by a single entity. Each paragraph is written by a different person with a different goal. I describe it in my code courses as a ransom note, a message clipped together from other messages. That it's the code is logical, but it's not A to B to C. And the kind of learning that I have no knowledge of AI in terms of how it works or developed, but my experience with it has been uniformly pretty troublesome. But the other thing is trying to get an architect to disclose when they used AI that on a certain level, again, like doing the Google search sort of thing, or as if you go into a website, whether it's Google or any other thing, you may get an AI answer that you chose to use so that the design professional is not going to be absolutely certain whether they used AI or not. How do they say that they did or didn't if they're not even certain themselves? It's a very difficult problem.
Yeah, I agree. I think we certainly need to pursue the effect of AI
Agreed.
and how it's incorporated into design by architects. But I think that the thing that does help cover everything is that ultimately, AI or no AI, the architect is the person in responsible control of that project. And they sign and stamp it. They have assumed responsibility for everything, whether it's AI generated or not. So there's somewhat of a comfort level there in terms of the coverage from a legal standpoint, safety standpoint.
Rather than requiring revelation of the use of it, it might almost be better to try and educate the architects that we're regulating to be a little to be cautious about the results they're getting. I mean, basically that that tell them to think twice or take all of the AI answers with a huge grain of salt.
Yeah, I agree.
Leonard? In my opinion, and the whole AI thing, I came across it a couple of weeks in the practice of law, weeks ago in the practice of law, where this attorney had filed a petition entirely made up of AI, and it was a hallucination.
Yep.
I agree that to the extent that it's a tool, I have no problem with people using AI as a tool, as long as they QC it before putting it in their final product. So instead of asking them in the beginning to own up to the use of AI, I would go to the end and say, listen, we don't know if you used AI and we honestly don't care. But if something goes sideways, we will double your penalties if we find out that it is AI, because we can. You can actually reverse engineer it and figure out now, there's no way that a person could have done this. Because, I mean, in my case, the cases that they were being cited literally did not contain any of the quotes that the other attorney was claiming they did by writing them out. So my thought is, the use of AI that goes sideways doubles the penalties, doubles the fines, doubles the damages. That, in my opinion, is the best way of approaching it. Because unless you have actual skin in the game, you're not going to fix it. You're not going to, say, okay, let me double check the quality of the answer that I got. Because all of us use AI on a daily basis. Whenever we check something in Google or any of those search engines. So that's my 2 cents.
Do you know what's happening to those lawyers that are misusing it? Are they get
Good
penalized?
question.
The response to their petition was basically basically rejecting everything and then seeking sanctions. The judge did issue a order as to why sanctions should not be imposed. The attorney came back and unreservedly withdrew every objection that they had submitted in their origin. And they, I was discussing this with a colleague, and we have never seen language that is so explicit by an attorney saying, "Oh my God, what did I do? I am so sorry." You know, pretended this never happened. Of course, that's not going to happen. But because lawyers love their pound of flesh, no matter what. So, anyways, my suggestion is, if we can somehow hip check the legislature to sort of weave this into our legal body of law, so to speak. If it is AI, if it does go sideways, any fines, any penalties, any damages, everything, they're just augmented accordingly. That's the only thing that's going to work, in my opinion.
There are frequent court reported cases now of these AI produced briefs, and I can't say the percentage, but there are a number of cases you read about in the literature where there have been heavy sanctions on the law firms for filing briefs like that. Sometimes the penalties are exaggerated, where you try and claim you didn't, and then you get caught. Also, some courts require when you make a filing, you have to certify if you use AI, you site check yourself. So I think the attack on this has to be a little more comprehensive as to where we put the pressure on. Is it simply make the architect disclose they do that generally specifically? Do you have it so that the court equivalent recipient of the work product, like a building department, before you can get your plans in, you have to certify if I used AI, I personally checked everything over. I mean, these things are actually implied by the Practice Act, but maybe we need something more express statements at either or both ends. So I think maybe some inquiry as to other practices that handle this issue, which I'm sure every occupation does, might be warranted before we really decide how we want to go. But I do think we need to investigate potential solutions without a doubt.
I agree. Agreed.
Okay, I'll go ahead and continue because we also discussed under the topic of current technologies, electronic stamps and electronic signatures. It's a question that we get from architects very often. And just like with the fiber example that I mentioned before, has led to clear problems because building departments do generally accept essentially a PDF stamp and signature. I don't know if any require actual digital signatures that are secure, but they certainly, a lot of them accept PDFs of signatures. And we have a lot of architects who are worried about that, about their stamp being used by other people, and we have found that to be true. We found a couple of cases where colleagues or contractors that the architects have worked with used their PDF of their stamp to submit plans. I suspect it's a much bigger problem than we can detect. So the question is there anything that we can do about that? And I'll just point out that there is a civil code, a pair of civil code sections that do essentially say, and they're on page 78 and 79, that a digital signature is as good as a wet signature in the state of California. And I think that that's pretty much the way we've been treating it. There's nothing in the Architects Practice Act that would be CCR 136 describes the architect's stamp and requirements. There's nothing that requires that to be embossed, for example. There's nothing that requires that to be a wet stamp or a wet signature. So we're kind of limited in our ability to regulate it by this state law that says that electronic signatures are acceptable for all kinds of transactions. So right now, we know that there is a problem. It's difficult to imagine how to solve it, especially if you look at the online platform issues. If somebody's going to commit fraud on that level, they're not really too concerned with our regulations to begin with. So I just wanted to put that out there as one of the topics that we discussed under current technologies. And I feel like at this point, we're kind of limited by those civil code sections that allow digital signatures, electronic signatures, and probably electronic stamps.
Is it worth approaching one of the validation companies like DocuSign to work with them such that an actual registered architect could validate that they have a license and that their stamp and seal are accurate? Because I mean, kind of a second tier for what an electronic signature would contain.
So there are a lot of state laws in special occasions, like the transfer of health information, that do require that sort of secure digital stamp, and we use them here for certain transactions within DCA and even within CAB. So it would be a matter of, I'm sure that building departments are aware of this problem. So it would be a matter of helping them enact something that would require a more secure signature system.
Yeah. It seems like sounds like the technology is there, and it would be common cause with the recipient of that, with the building departments, because this is definitely not even the wave of the future. This is the wave of today. More and more jurisdictions are only accepting electronic submittals. And so this is
On the
a
other
real
hand, I
problem.
think we found out that New Jersey still requires a wet stamp.
And you're right, Steve, my stamp pad has dried up over the years.
Yeah, I mean, that basically, I think that that's clearly going to be what happens in the future. So we should.
So we'll
this
come
is a
back
problem
and,
that needs to be addressed.
unless you
Anything
want
else
to take
on that
public comment
topic,
on this,
from you on the topic 3, Mike? Anything else?
That's it.
3? That's it?
That's all.
Okay, moderator, why don't you open up for any public comment on the discussion under F3, if you don't mind?
Sure. If any member of the public would like to comment, please raise your hand by clicking on the hand icon next to your name, or if you've called in, pressing *3. We'll give you a moment. All right, this is a moderator. I see no request for comment. I return the floor back to you.
All right. I think, Laura, on F3, there's nothing to action to take, but just this is such a hot topic and of interest to the board. The February meeting is coming close at hand, but to the extent you get any more information, knowledge, input that you can just, relay to the board, subject to what Mr. Jones wants to do, I think would be appreciated even that soon. Okay.
Sure, thank you.
Okay, item F4. Who's going to take the lead on that?
I am Jasmine Steinhardt. So this goal, F4, the stated goal was to pursue legislation to update the business entity report form, or otherwise called the BERB, to include more information about the management control of businesses. So the goal of including this information is to better capture and communicate what management control responsibilities within architectural firms. It's having management control. It relates to what you can advertise your services as, and it's not greatly understood. We want to be able to improve transparency and accountability and support our enforcement and efforts by providing this information. We considered to achieve this goal, we spoke with Tim Rada, who is the regulations manager, and we determined that we don't need to update legislation. This information is already in the act. It's already, an architect has to be in responsible management control. This form is really, it's our own form, so we can update it to allow licensees to volunteer this information. They don't have to check the checkbox if they're not in management control. But we also did include, the definition of management control in that to advertise architectural services, there needs to be an architect in management control of those services. So we included that information on the BERF. So it's now on the BERF right there, right after the checkbox says I'm in management control. We allow licensees to better understand this information, how it relates. So we updated the form. We included the checkbox to notify us if they are in management control. We included the definition of management control. We also improved outreach. We posted this new BERF, and we also created an informational bulletin. And those were posted together on the board's website, and they were also posted on the board's social media. I know for sure it was posted about on LinkedIn, and I believe also on X. So that has been done, and it's also, we're working on getting it uploaded to Connect, to the board's online portal. So when licensees renew their license, it should also pop up there. So that it's a work in progress, but that's the Connect team. And that is about it with this item. So really what we're asking the committee is just to review what we've done and just
Check
approve
it
it,
out.
and recommend goes to the board as a complete objective. So included attachments are, this is Business Professions Code section 5558. This is the section that has basically the address of the record. This is the information that architects, if they're providing services in California, they need to provide this information to the board. And so the BERF allows them to do that in a convenient way. The next attachment is California Code of Regulations section 134, and that is where the advertising requirements are, that there needs to be an architect in responsible and management control to allow a firm to advertise architectural services. We see this come up a lot. It is not greatly understood. And it's also includes subsection C, includes the definition of the term. So management control, it just means general oversight of professional services. Again, it's not well understood or well known. So hopefully by adding this information to this form will allow us to get that information out there to architects. We also included the previous version of the form and the previous version of the informational bulletin that we created. This was back in 2021. So it's been a couple years. So we also included an informational bulletin about responsible control within design and design firms. This bulletin was created in 2022, and we have it on our website. We use it a lot with just to allow firms and licensees to know what their responsibilities are. If they are an independent firm, they're saying they're responsible control. Well, here's your responsibilities. And for all relevant sections, that is available on our website, I believe. The final attachments are the newly updated version of the form, which is currently up on our website, and it is attached to the informational bulletin, which includes a little more information about the updates to the BERF and why it is there and why management control is required for advertising. We're trying our best to attack all avenues and get this information out there.
So let me understand. So the new Burke form that adds I am in management control, is that already active and on the street, or you need us to bless it and for the full board to bless it before you release it?
That has already been approved. It has been uploaded. It is active. It is on our website. So this is more just for the committee to see this is what we've done to achieve this. And just recommend it to go to the board as a complete objective. And it's also going to be in the upcoming newsletter. So anyone that signed up for the newsletter will receive this information as well. So again, trying any avenue we can to get it out there to architects.
Questions, comments from committee members?
I don't suppose there's any way to put the most current version, the version, some sort of version identifier at the bottom of the document, is there? You know how, as I don't know if any of you guys have done this recently, if you've applied for a job with the state, you have to file, standard form 678. And then there's the, a little version
Yeah,
identifier.
I mean, we could add it.
Yeah.
Good idea.
Great.
Right now, the form itself is attached to the bulletin, which does have the 2026 date on it, but we can put the date on the form itself.
All right, first moderator, could you open for public comment on this item F4, please?
Thank you, Mr. Chair. If any member of the public would like to comment, please raise your hand by clicking on the hand icon next to your name, or if you've called in, pressing *3. We'll give you a moment. All right, I see no requests for comment. Mr. Chair, I return the floor back to you.
All right, given that the agenda had an action requested passage for this item, would any committee member want to make a motion that we approve this staff report and this strategic plan objective and recommend placing the item on a future board agenda item?
So moved.
Second.
Okay. That was Bob who seconded, or Steve?
Steve.
Okay. Okay, could you take the roll? Vice Chair Manoukian, please? So,
How did I get this job anyways? Okay. Okay, so Robert Pearman,
aye.
Leonard Mnuchin, aye. Robert Chase,
Aye.
and Stephen Winkle.
Aye.
There we go.
All right, so unanimously approved. Very good, very good. All right, the last is the additional training for subject matter experts, etc. Who on the staff is handling that presentation?
I'll start. Yes, the objective is to provide additional training to subject matter experts, board members, and staff to strengthen enforcement decisions and recommendations. As we are in the middle of hiring new SMEs, we're planning training for them that will involve some of the old SMEs and Bob, obviously. And so we'll have a full presentation for those people. As far as training staff, we have a monthly staff meeting here at the Architects Board, and we're trying to bring up more of the issues and cases that we work on so that staff here understands what we do. What we're asking the committee today to do is to recommend a topic or two for us to present to the board for additional training over the next year. And we, in addition to all of the topics that we've discussed already today, I've included additional topics such as the informational bulletins that the enforcement unit has published on design limitations, responsible control, most common violations, and business formation. We also have some interesting issues regarding the written contract requirement and how client is defined in that context, and also some issues around aiding and abetting and what sort of supervision needs to be implemented. Jasmine's going to talk about a case of hers that's presented in the packet as a hypothetical to illustrate the problem we have with defining who a client is in the written contract relationship. So we're looking at Business Professions Code section 5536.22, which is on page 96. And the hypothetical is on page 105.
All
So I'm
right.
gonna take up this one.
Go ahead.
We're really discussing this just to, kind of get your opinion as architects and lawyers, and also to illustrate the difficulty we sometimes run into with the act, the way it is written, and it does not, it implies things sometimes, so it doesn't come out right and state them, and that does lead to some difficulties. So a case, this is actually, we have had 2 complaints recently that are like this, and it involves, so this was an issue that came before, I think, the committee and the board in past years, and that's the definition of client. And we've never been able to define client because it's not the homeowner. It is, it could be anybody, it's just who the architect has a contract with. And so that leads to situations like the 2 complaints we received recently regarding third-party contracts and billing or invoicing. So these are just general, but so a homeowner hires a designer, and that designer can be either licensed or unlicensed to work on plans for an exempt project. The designer then hires a consultant who is a licensed architect for drafting or plan check services, which is allowed by the act, that relationship. They're allowed to have partnerships or hire architects. The consultant, who is a licensed architect, provides services on the project and then invoices the homeowner directly for those services. So this is where we run into problems because the homeowner is not the client. The homeowner is not the person they have a contract with. And so so these architects, I don't know why they believe they have the right to invoice the homeowner directly. So our questions are kind of, is it standard practice or acceptable practice for an architect to invoice the homeowner directly when the homeowner has only contracted with the designer?
No, it's not acceptable.
But why?
An architect can only invoice the person they have a contract, whoever that client may be.
So we're saying it is implied by the word client, that they can invoice only their client. That's the person who's going to be paying them.
I don't think the implication would hold up in court. I'll defer to the attorneys for that.
I'm gonna wait.
Well, I'm not a practicing architect, but in the general concept, I often encounter situations where you have a relationship with one party and you agree, but I'm going to send the bill to someone else, and no one objects and it works fine. I guess if that other someone else decide not to pay, then you might have an issue. But that concept just in the business world is not uncommon or unusual.
My
I think it should be specified in the contract, though, if that is going to be the case.
Well, my question is this, and it may sound silly, but bear with me. Why are these architects doing this? I mean,
It's a good
what is the
question.
benefit to them for doing this?
I mean,
It's really unknown. I don't know why they're doing this. I don't believe it's proper practice. I think the written contract section is very clear that your client is the one you're agreeing on the method of payment, the services you're providing. And typically what we see is that an architect well, usually it's an architect, they have to have a contract. If they hire another architect as a consultant, when their contract with the homeowner will say, oh, if I hire a consultant, I will hire that consultant and I will charge you whatever they invoice me. Or they will say, you, the homeowner, will hire consultants. That's typically the two ways we see it done. But this is the third way that we've seen in 2 cases recently. And I don't know what is their thinking in this. I don't know why you would invoice a homeowner you don't have a contract with. But
I
it
just think they made a stupid mistake. They weren't thinking. Because, okay, so in the working, there's only one area that I can think of that this, and that's why I asked the question, that doing what is being done makes sense. But that has nothing to do with this arena, because it has to do with workers' compensation, right? In workers' compensation, if you want to maintain your independence such that you can say forever, I'm an independent contractor, okay, you may send your bill to the principal. You may do that instead of going through the general contractor. Okay.
Yeah.
That's one area. But I mean, how does that even relate here? It doesn't. That's why I asked, okay, it's either intentional or it's just a mistake. If it's an intentional, if they're doing this intentionally, they must have a reason. If we ask them what that reason is, we may be enlightened such that we can rejigger our practices to simultaneously take care of our take care of architects as well as the consumers.
So
Now-
my understanding it is not proper practice and would be considered, I would say at the very least, a violation of the written contract section. They do not have a contract, but they're invoicing this person.
Well, Jasmine, in this scenario, the consultant architect must have a statutory suitable contract with the designer, correct or not?
That's my question.
They should, yes, because
Okay.
that designer can be their client and that would be fine, but they have to have a written contract with that designer.
Mhm.
However, in one of these cases, we have a related issue where the designer is a licensed engineer. And there is an exemption to the written contract requirement where an architect providing services to a registered engineer does not have to have a written contract. So I don't know what the intent of that exemption was when it was written, but now we have this situation where there may be no written contract at all in this situation. And this architect is invoicing the homeowner, but this is my client, I don't have to have a contract because they're an engineer that I'm providing services to. And so it's just, these are the kind of issues that come up and we're not sure the intent of this exemption, but these are the case studies that we're seeing.
What?
Jasmine,
My
have you
guess-
asked?
Go ahead.
Okay, Bob, have you asked that architect who is submitting the invoice to the client why they're doing it that way?
So these are new complaints. And so we wanted to kind of bring them up here because we don't really come across this very often. And just kind of get the committee's reading on this to get the kind of approval it is my understanding that the client is the person that you're going to be invoicing because you have agreed on methods of payment with the client. And so I wanted to get, the committee's read on that section and their approval before we reach out to the architect to ask them, because if that is not the reading or the intent of that section, then
what jurisdiction do we have over this?
I would certainly suggest that you reach out and ask them what their reasoning
We're
was.
still at the phase, we're trying to, before we do that, in every case, we try to identify the potential violations. And so we're still at the phase of trying to figure out, especially since this is an engineer, and arguably the architect doesn't have to have a contract with the designer. What would the violation be for just sending an invoice to the homeowner?
Let me posit another different scenario, but let's say it was a non-engineer. Let's say it was a home designer or a designer, so that there's an obligation for the architect to have an agreement with the designer, the person in the middle. There's the homeowner, there's the designer, there's the architect. The architect has a contract with the designer. Could not the terms of payment in that agreement between the architect and the designer state that in the event when billing time comes, I will submit my payment request to the owner? Could that not be in the agreement?
I mean, I suppose it could, but I believe
Because
in,
the reason they'll do that, and this is basically what you're trying to do, is avoid markup. Basically, I don't want to handle my consultant's paperwork, and they don't want to send me the paperwork because I'm going to charge them 10%, or the owner doesn't want me to do it either, the client, because I'm going to charge a 5 or 10% markup for handling that paperwork. So if I skip a step, everybody saves money. That's the reason you do it.
I suppose that is possible, but in both of these cases, the architect was unknown to the homeowner. So they're being billed by this person that they don't know. They have not agreed on rates with this person.
So in the
So that's an interesting question.
designer and the client's, the homeowner's contract, does that contract state that there would be a external architect hired where the architect would then invoice separately from the designer to the homeowner? I think that's where you would have to close that loop so that everybody in this project is aware of what the project scope is, what the billing and invoices are gonna look like, who they're coming from. Because honestly, if I got an invoice from an architect that wasn't my designer, I would think it was a scam and I would refuse to pay it. That would be my perception as a client.
But then are we making the architect responsible for the designer's contract?
Well,
is the
yeah, why
designer-
wouldn't you? Because you would be signing and agreeing to it.
But the
Are you
designer,
talking about the designer's contract with the client?
but is he obliged to, he or she is obliged to have a contract at all? They're non-registered design professionals.
Why
But
we're saying this is
we
improper.
can enforce.
This has to be a violation of the act. It's improper
Okay.
contracting on the
Uh,
architect's part because there is no written contract, or at least doesn't have to be. But in this case, I think
Yeah.
Stephen, your question was if they included a clause stating that the consultant would bill the homeowner, and no. In one of the specific cases with the engineer, which
Yeah, there's
we have
no
no
con-
jurisdiction for what the engineer's contract contains, but I believe it did not refer to hiring of outside consultants. And all it said was that it was a fixed fee contract. And all it said about any hourly rate was that outside of the fixed fee, any changes, the engineer would work on them for, a certain rate. And the rate the architect charged, the homeowner was higher than that rate. So the only rate in the contract, the architect has now exceeded. So you can see our concern.
Oh, yeah.
Well, okay, so taking a step back, when you
Oh.
enter into a contract for services, it is implied that you're allowing the person that you're entering into the contract with to go out and secure whatever they need to provide you with those services, right? as a general concept. Now, so I, as a homeowner, go to a designer, I go, I need XYZ. That designer goes to an architect, the architect sends it to me. Now, I honestly don't mean to, you know, make this smaller than you guys think it is, but it seems to me it is. Because, okay, so the architect sends me the bill. I look at the bill and I go, I don't know who this guy is, but oh yeah, I am having something done. I pick up the phone, call my designer. Hey, Joe, do you know anything about this guy? Oh yeah, that's the guy who I hired. Okay, you know what? I'm just going to send it to you with a check. You take care of it. Or, oh, okay, that makes sense. I'll cut him a check. In any event, to address the underlying concern that I just noticed when you were talking, that hey, the architect, the numbers don't match up because the homeowner entered into a contract for X number of dollars. Now they're getting an architect's bill that's X times 2 or whatever. Okay, that's a contract issue. That's not a, you know, because now Leonard is going to call Joe and say, hey, Joe, who is this guy, this architect from? Oh, that's the guy that I hired to do your job. Oh, okay. Now I understand it. But you do understand that our agreement is that I'm going to pay you X number of dollars. This guy's charging me 2X. Oh, no, Leonard, that's wrong. Send it to me. I'll fix it. Or whatever. I don't understand. Maybe I'm, you know, and I don't understand why this is an issue, because in the regular way business is handled in people's daily lives, things happen, mistakes are made, stuff, you know, people pick up the phone and call each other. I mean, we don't have to call it improper or a violation just because it's somebody had a, you know, there's a term that I want to use, but I'm being recorded, so I won't. But I mean, somebody just, their brain doesn't work for a second.
How did this end up in your in basket at the board?
So what I will say is that in an ideal world, yes, that's how it would work out. There was a mistake, someone called someone else and they got it fixed. But we're in the enforcement unit, so we receive complaints about the architect's conduct. So this is something, at least these are multiple cases where that has not happened, that this person, the homeowner, is being charged by an architect and it is not being resolved by the architect. So we have concerns about the architect's conduct and not having a proper contract. And is it misconduct? Is it a great conduct violation to be invoicing someone that is not their client? That is what we're trying to resolve, because these are situations we receive complaints.
Are
These were obviously not resolved through speaking.
Are the complaints from the homeowners?
Yes.
Okay. Like, so it is the mystery bill. Why did I get this?
Yeah.
Yes, and it wasn't resolved by speaking to the designer in the middle. They're being invoiced by someone that they have no idea who it is. They didn't agree to this person's rates. The charges may not even be in their agreement with the designer. These charges are above and beyond what they've already agreed to pay. But now their plans are being held up because the architect is saying, whoa, I haven't been paid.
But I think it's civil contract law. If a homeowner is, you know, invoiced for something that they don't have a contract with the person for, why would they pay it?
Yeah, I guess I'll defer to the lawyers for that.
Yeah, they wouldn't. There's no privity of contract. The homeowner is protected. The architect is out of luck. The designer needs to, you know, make them right, make them whole. And by them, I mean both of them. Because they have a contract, presumably by both the architect as well as the homeowner. So again, the law writ large protects the homeowner, not necessarily through you know, the architect's board or consumer affairs, but through civil. I mean, to the extent that they are like, "Oh my God, you sent me a bill. How could you?" Like, okay,
I'm going to complain to the architect's board. Yeah, it's the first reaction.
Let me go back to my other question, which is, should the architect have, under the Practice Act, should the architect have an agreement with the designer, since that's his client, which is clearly required under the Practice Act?
Yes,
Yes.
isn't it?
Well, in this case, we don't know yet. But
Well,
that's the
that's-
second part of the question.
That's what we're saying is that, we can't define client. Client doesn't mean homeowner. So the architect should at the very least have a contract with the designer who is
I
their
think so.
client.
Yeah.
However, in one of these cases, the designer is an engineer and there's a contract exemption for that. So there may be no contract at all.
But I would
the
say,
architect, I'm sorry, Stephen,
Yeah.
but the architect is basically walking into a trap. They are
Yeah.
basically acting to their own detriment, but not. I mean, if I'm the designer, life is good, right? I can just walk around and just do things for different people with no contract. On the
Yeah.
other hand, if I'm an architect in this context, I'm like, wait a minute, this is a suicide pact.
yeah,
Nobody owes me a dollar for all the work that I'm doing. So,
and I would also argue that even though the engineer, is not required to have a contract with the architect, I think the architect treating the engineer as a client, as I would define client under the Practice Act, is required to have a contract with the engineer. I think the fact that it doesn't go from the engineer to the architect doesn't get the architect off the hook to have a contract with his client, who is the engineer.
I'm sorry, Mr. Winkle, are you saying the architect should have a contract with the engineer or the architect should have
Yes.
a contract with the homeowner?
No, the architect
There
should have a
is
client
a-
with the engineer.
So the
Even
engineer
though
is
the
the architect's client. Yes.
Yes,
There is an exemption to the written contract requirements that an architect providing services to the engineer is the architect's client. In that circumstances, there is an exemption that a contract is not required. The architect is not required to have a contract if they're providing services to an engineer.
in the
Okay,
practice,
that makes
in the
perfect
Practice Act.
sense. Okay,
Yes,
I
yes.
get that.
Mhm.
But an exemption doesn't mean, an exemption means that I don't have to do it. I can do it. If I want to
Yes.
protect myself, I can do it. Well, this
Yes.
architect didn't think things through. They ought to have gotten them, despite the fact that they're otherwise exempted. Listen, if my sister is a professional engineer, by the way, right? And I'm a lawyer, right? I may provide her services. She may provide me services. She's my sister. I'm not going to harm her. I'm not gonna, not pay her what I owe her. But if I were a stranger, well, why then I would say no. I mean, I know you're an engineer and you're exempt from having a written contract, but you know what? I think it inures to the both of our best interest to have a contract. That exemption, although within the four corners of the law, it ought not be binding on one's common sense.
I think going back to common sense, the architect initially should have said, okay, I can do this work. Who's going to pay me for it? And how do I ensure that I'm going to get paid?
Exactly.
So this is Laura. So Jasmine, this is an example kind of an issue that staff deal with that you're looking for feedback on, but we're not looking necessarily to resolve it today. It's something I think we're gonna have to pursue with our legal counsel as to exactly what we can do. Is there more you're looking for from the members today?
We want to illustrate that these are the issues that we see coming up, and they are very complicated because there's requirements, there's exemptions, there's what's the definition. So yeah, it's just more.
The long range picture is that this could end up in closed session before the board. And your analysis might be completely different from our analysis. So our question is, what can we provide? What training can we provide to the board to make sure we're all on the same page? Either
Well,
about this topic or any of
it's
the
a
other
difficult
topics in this
situation.
section.
It's a difficult situation, so there may not be no clear answer. My thoughts, I have three comments. One is, I thought the simple possible explanation for this arrangement was just the architect did not want to deal with a pain in the ass homeowners, and this way developers deal with them, plain and simple. Secondly, I think you should look at and speak with legal whether the concept of services on behalf of means professional service to a client. So even though they try this arrangement, when ultimately the services are on behalf of the client, maybe that's enough of a trigger if you had to try and invoke 5536.22 in this type of case. And lastly, I think philosophically, I think from our board and our Practice Act obligations and our consumer protection, there has to be, when an architect is providing services, some sort of contract in writing that defines the work, defines his or her Practice Act responsibilities, and other things. So I think that if I were acting as Laura and how I would handle these, I would say, when that's missing, there's a problem and we won't accept that. So
Thanks,
is
Robert.
this something that in general, you're going to look at and give some more thought to these options, or is this just a certain isolated example, but just part of the kind of considerations you want to make to bring to the board's attention from time to time in the future?
Well, under the topic of training to the board, it would be a question of, would the board be interested in hearing about written contract requirements and their exemptions in general, aiding and abetting and the requirements for that, or these bulletins that we've published? What are the topics that you think would be useful because they're especially difficult? This was a great illustration of why we enjoy our job, because we get to have these discussions every day, but we'd like to be able to provide some helpful training to the board members.
Yeah, I think from speaking myself and my observations, something on the written contracts would be useful, and the purposes. Sometimes we've gotten cases with minor technical violations of written contract requirements, but with a further explanation, maybe staff has explained why, you have to do this because the tip of the iceberg is out there when these things aren't followed. And even in this case, of course, the whole concept of whether one is required in circumstances is invoked by looking at what a written contract means. So I think that broad term can encompass a lot of education to the board members and dialogue with the staff.
So you're recommending that we start with written contract trainings with the board and then move on to some of these other topics like design limitations or things of that nature? Is that what you're recommending?
Yeah, and it seems logical too, because that's kind of the fountain by which everything goes, right? The contract sets the basis for everything else in the relationship. But that's one man's opinion.
Yeah, I think the written contract requirements is a good place to start. That is a lot of what the board ends up seeing.
Something came up in the conversation earlier too, that we've realized for years, what are the probably primary basis for violations and issues that come up is lack of communication.
Yeah, right.
Just following the requirements.
I think also, if I'm understanding what Leonard was talking about, is I think education for the licensees, such that even though there may be an exemption for an architect engineer agreement, that you should use that exemption with very carefully and very sparingly in terms
Make a
of
newsletter
not,
article.
not leaving
Well-
yourself out in the cold
What I'll
as an,
say
as
is
an
that
architect.
Right.
that is why written contracts was such a big part of the videos that we just released and we watched
Yep.
today. The written contracts are there to protect both parties. And we include
Yes.
all the in that video that were just published. We're hoping to get that information both to consumers and to licensees. So
But I think that the message is don't take that off ramp, even though it's offered to you for not having an agreement.
yes.
Yeah. Okay, good. Anything else on F5 from the staff?
No.
Moderator, would you open up for any public comment on, I guess, 4 and 5?
Thank you, Mr. Thank you, Mr. Chair. If any member of the public would like to comment, please raise your hand by clicking on the hand icon next to your name, or if you've called in, pressing *3 or displaying instructions, and we'll give you a moment. All right, I see no requests for comment. Mr. Chair, I return the floor back to you.
Thank you, thank you. Anything else? I see nothing else on the agenda besides adjournment, but am I missing something, Laura?
No, I think we've covered everything. Thank you. Thanks everyone for your participation.
All right, appreciate it, committee, appreciate it, staff. And we'll see some of you folks in Palm Springs in a few weeks, right?
Would you like me to do a roll call? Just kidding. Don't be-
You're off the hook, Leonard. You're done.
All right, Leonard, take care.
All right, take care,
Bye.
everybody.
Thank you.
Thanks to the staff.